Hello and welcome to another episode of Hey, Not the Face with your host John Nash and your producer me, Steffi Haynes. And guess what? We have a brand new UFC contract. Actually, John was given access to several brand new UFC contracts, and so he is going to basically put them into a collective situation and will be able to disseminate any new changes that John has noticed over the course of this episode. John, how are you? I'm excited.
Oh, I don't know about it. I can't believe you're excited. It's the exciting world of contract language. But yeah, we have the UFC we just finished an episode, and now we've noticed they've made changes. And it seems like just in the last few months, they've made changes to their contracts. So we're going to go through those changes. Unfortunately, because this wasn't posted in a lawsuit, I can't post the whole contract. So we're not going to post the text itself because, we don't want to out anybody, but we are going to discuss it's in multiple contracts. So it seems to be the new standard. So we can say that.
All right. And my first question, I guess, is, how did we get the contracts? Was this something that you inquired on? Were they volunteered? How did we get so many contracts to compare?
Well, I collect contracts, and a lot of people know that I collect contracts. And after I've been talking about sunset provisions and all this stuff for so long, some people reached out to me to discuss some of the terms because they were looking at a UFC contract and it didn't seem to match exactly what I described. And so I realized there might be a new contract. So I sent some feelers out, and various managers and fighters, they were kind enough to either show me their contract, describe what's in it, give me excerpts, or even give me the contract. So we have a sum of several contracts we can use and look at and see what's in all of them, and also what are the changes from the previous contracts that we had.
I guess my first question, if you were to select one section or one huge change, the biggest change of them all, what would be the number one thing that pops to your brain?
Well, the biggest change by far, in my opinion, is Section 25, the choice of law and dispute resolution, which is about we already know before that they use the law for court contract and argue this, for all the legal purposes, it's based in Nevada. But this is a whole section. This is several pages of new stuff added into the contract. And what the big part that's been added is an arbitration clause has been added, a whole arbitration process, and also a waiver to class action. So we'll get to both of those. But that's a pretty big change to their UFC contracts.
Tell me first about arbitration, because when you sent over the excerpts so that I could personally view them, I was absolutely flabbergasted with what I was reading about arbitration.
Yeah, well, I've heard rumors. There have been rumors for years that they included arbitration in their contracts, but no one could confirm it. And I'd ask around, and maybe they were testing it or suggesting it to occasionally fighters, but it never appeared in a contract until last few weeks, last few months. But the more recent contracts we've seen has this arbitration. And if you remember the hearing in September of last year over the Kung Lee versus Zuffa antitrust hearing, actually, I think it was the Johnson v. Zuffa hearing, but they were doing a hearing on the status of the lawsuit. And they had mentioned, Eric Kramer, the plaintiff's attorney, had mentioned that there had been an arbitration included into the plaintiff's or the defendant's contracts. Now, at the time, it sounded like he was talking more about the provisions like the sunset clause and the changes that help fighters. But maybe he actually meant arbitration, and that they knew that this was coming, because the arbitration, what it is you cannot directly sue. You can't bring the UFC to court anymore if you sign this. If you sign this agreement, if you have a problem with the contract, you can't go to a court to sue them and claim that the contract's illegal or that you want damages. You agree that you're going to go to arbitration instead. And there's a lot of benefits to that for the UFC.
Arbitration is typically in-house, correct?
Well, it's a third party. There's some rules. They use the JAM system, so technically it's a third party. But yeah, it's not. When you do arbitration, the results stay in-house. It's not public. The information does not go public. I can't look up filings for arbitration and get the contracts like I can with like the Mark Hunt case. I've been posting excerpts from the Mark Hunt filings. On an arbitration, none of that appears. It's all kept kind of secret. And, and the public and the other fighters are all kind of kept in the dark. What are the results of arbitration?
One thing that I noticed was that if something happens with the antitrust suit that affects portions of the contract, it specifically states, okay, this part of the contract will be stricken, but the rest stands. How do they do that?
Well, it basically argues, it says anything in the contract that's deemed kind of illegal or unenforceable, that part is so if you challenge your contract and say my contract is coercive and illegal because it breaks the law in these categories, we look at these provisions, the UFC, they're making the case that those portions can be taken out of the contract and be removed, but the rest of the contract stands. They're still going to claim that it's still the rest of the contract's enforceable. But the other parts of arbitration is, arbitration works to the UFC's benefit in many ways. I guess, a lot of people might think of arbitration might be good for fighters because, there's a famous case that Major League Baseball when Marvin Miller in baseball went to arbitration to overturn the reserve clause. But that was a different standing for arbitration. In this case, there's no precedent set when you go to arbitration. It's not universally applied to all the players, all the fighters. So if you go to arbitration and you win a decision, right? That's a self-contained decision. Mm-hmm. The next fighter can't point to that arbitration and say, yes, the arbitrating judge ruled that this provision's illegal. I want the same ruling. No, they have to look at it and basically re-rule it all over again.
Yes, and that's the part that really stood out to me because in those cases, nothing goes public. So hence my comment sort of stays in-house. It's very, very contained in a box. The box has no windows. Nobody can see in.
Very much. But even bigger than the arbitration, this is the part of the arbitration process is there's a class action waiver attached to it, meaning you cannot go sue the UFC as part of a class action. You have to take your complaints to arbitration first. You have to go to arbitration. And this is interesting because the Supreme Court ruled this legal in 2018. So the problem, you have to guess that the UFC in 2017 changed their contracts and then decided to include this waiver for for class action and for arbitration after that Supreme Court ruling made it possible for them. So, but if you read it, if you look at it, you'll see that there's a carve out for the Kung Lee case. So in other words, the Kung Lee case, they can't force you to sign a waiver for that case, but not mentioned in that carve out section is the Johnson, the second antitrust lawsuit that starts in 2017 that they're trying to do as class action. That's not mentioned. So fighters signing this waiver, this waiver from class action, they cannot participate in that class action if it's granted class certification. And so that limits the pool of fighters that are available for damages in that case if it goes forward. I have to imagine that the plaintiffs are going to challenge this. You have to, even though the Supreme Court has ruled on it, I don't know if it was ruled in if you have a monopoly, they're arguing the UFC is a monopoly. And so they're going to say that a monopoly is allowed to put in a contract a provision that says you can't sue us for being a monopoly. That's basically what they're saying.
Right.
And it seems impossible to figure out how that could be legal because the power that you're claiming they're abusing, they could then be using to prevent you from challenging that power. And so I got a feeling that will be challenged. It has to be. But for now, they have a waiver for the class action lawsuit. and that prevents any future fighters from signing this from taking part in a class action against the UFC.
Let's move on to changes to terms in Section 12. The matching rights, the negotiating period, things change there?
Yes. Well, if you remember in the old contracts, and Nate Diaz had this contract, that there was an exclusive negotiating period was about 3 months. And then there was a matching period for the UFC for 12 months. So you had to, for 90 days, you had to negotiate with only the UFC. And after that, the UFC had 12 months to match on the offer. Now, the more recent ones we had a hold of, and we had, multiple contracts. The most recent contracts we had had a matching period of 12 months, but there was no exclusive negotiating period. I didn't see that in contracts from 2017 up until last year. I was not seeing that. I did hear some people told me that the Contender Series fighters had, I think it was a 3 or 4 month matching period. and 1 month negotiating period. But I didn't get a hold of any specific contracts that had that. Even the contender ones I had didn't have that. But these new ones specifically have that. The ones I see now, there's a 1 month exclusive negotiating period, which they didn't have before. But the matching period has shrunk from 12 months to, I can't remember if it's 4 or 3 months.
4.
To 4 months. Thank you.
Yes.
To 4 months on the matching period. So you have an exclusive negotiating period, which stinks. But you've shrunk down the matching period to only 4 months. So that's probably, you got to say, is a net benefit to fighters.
Okay. Now, there's also changes to terms in Section 4. And I want to highlight this section because we've mentioned it several times already in this podcast, the sunset provisions. And Section 4 contains something about those sunset provisions.
Yeah, if you go to they never call it a sunset provision. We call it because that's basically what it is. But if you go to the last provision, it's the notwithstanding the foregoing, meaning all the provisions in that section fall under this. The agreement will not be extended pursuant to the Section 4 beyond the date, which is 5 years after 5 years. Now, notice the change in this. It's not the 5 years is not after the signing of the agreement, which is what we saw before. Remember that whole confusion with Francis Ngannou where I got it wrong. But this one is that it's 5 years after the fighter's first bout under the agreement. And it has me thinking, I got to go through all my old contracts because I probably ran into a similar language at some point, making me think they all were like that. But we're back where it's not the first fight it doesn't start at the date that your contract signed, the signature date, right?
Right.
It actually starts on your first fight.
I have an example for you already.
Yeah,
Bo
yes.
Nickel. Bo Nickel signed a contract months ago.
Yes. Yeah.
He's been signed for quite some time. He doesn't have a fight on the immediate horizon. It could be a year before he has a fight. This guy, his contract could be going for a year.
But yeah, it could start. The sunset clauses, we're going to call it, the 5 year maximum length, could start when he gets his first bout. And let's say he gets injured or they can't find him a bout. A whole year goes by. Then he gets his first fight. Now, even though he signed a contract, he can't fight for another promotion. The 5 year period starts at that first bout. So it could end up being a 6 year period under contract then. On top of that, the previous one covered everything, any sort of extensions, suspensions, whatever, were under that 5 year period. But now they have another carve out, and the carve out is this 5 year period doesn't cover periods where a fighter is unable or unwilling to compete because he has been suspended by either the athletic commissions or anti-doping agency, the USADA deal. So if USADA suspends you or the athletic commission suspends you for 2 years, and you can't fight. Well, the previous deal would cover that. So that would be part of the 5 years. Then when you're done, your contract be terminated. But now your fight for 2 years, you get a 2 year suspension. Well, you still have 3 years left on that total length before the contract sunsets.
Wow. That's awful.
So on that front, that is not a net benefit to fighters, I think we can all agree. That is, it's not the end of the world. Just hopefully you don't get busted for steroids. And so you don't have that, but it adds months to it because it starts on your first fight now when you sign. And if there's any sort of suspension, let's say, a good example is like Nick Diaz for marijuana, that suspension. Mm-hmm. The BS suspension. Well, guess what? His contract is now frozen. If he had signed this agreement and that happened to him, the 5 year period would be extended by the length of time that they suspended him. The athletic commissions.
Tell me if this covered any of the parts in declination.
Well, the declination in this is when you decline a fight.
There you go.
And so previously we had, the agreement was that the UFC, when you turn down a fight, they can extend the agreement by your current contract length by either 6 months. So if I have a 5-fight, 20-month deal, it's now a 5-fight, 26-month deal if I turn down a fight and they can extend it for 6 months, or as long as it takes to find a new bout. Now, if you remember on our previous podcast, we talked about contracts. We did say that there's a maximum length that they can extend it, 18 months. In other words, if you're pulling a Nate Diaz and you keep turning down fights, well, after 18 months, they can no longer keep extending your your contract, right?
Mhm.
That's the max amount of time. They remove that right now. I'm not seeing that in the contracts at all anymore. There's no maximum amount of time they continue extending the contract. So they can keep going 6 months every time you turn down a fighter, how long it takes to fight her. The max amount of time they can do it now is the 5-year sunset, not the 18 months they had before. So again, I would say that's a net negative for fighters. That's a little worse than what we saw before.
Now, there's also been a change to retirement as far as sunset provisions, correct?
Yeah, there's another I've noticed something different. This is that where before it was a 5-year period if you retired, the suspension period, as they call it, will not exceed 4 years. So that's been shrunk to 4 years from 5. The confusing part for me is, and we might find out this with Conor McGregor, is if you retire, right, does that supersede or does that on a parallel track as the sunset provision, the 5 years? So Conor McGregor, we don't know why he got out of USADA, but one of the theories is he technically retired from the UFC for a period of time, right? And so USADA stopped testing him. Maybe he got an exemption, he didn't retire. But one of the theories I've heard is that he retired technically from the UFC, and so he's no longer getting tested. Well, the question is, he signed his contract in 2018, in fall of 2018, his current one. His sunset should be up this fall. But if he retired, is that a separate track? So is his contract not going to sunset this fall? Because you got to take that retirement period and add that onto it as a separate track.
What about with the Ultimate Fighter? He had to have signed something for that, right?
Well, yeah, I mean, that's part he could sign on to the agreement. That falls under the notwithstanding the foregoing. The amount of time they can extend your contract under when you on the Ultimate Fighter, which is like 6 months, that falls into under notwithstanding the foregoing on the sunset clause. So that does not add time beyond the 5 years. The 5 years covers you still, even if you're on the Ultimate Fighter, when the 5-year mark hits, it's up. Your contract's done.
There was another change, and I couldn't help but notice this one too. Code of conduct, wagering.
Yes, this obviously was added probably months ago, because remember there's a lot of talk of that. But I noticed it in the code of contract now that they specifically mentions athletes are prohibited from placing any wagers on UFC matches, them or third party, and people associate them. So basically covering all the stuff that the Krause situation has brought to light. And what's turned out something of a big scandal with the promotion. And so now they have it covered explicitly in the UFC code of conduct. Yes, you cannot, your managers, your handlers, anybody cannot put any bets on UFC matches.
Including on yourself. Which is, to me, it feels a little weird because it's a common practice for years in boxing. I mean, some states have regulations against it, but I mean, that's how boxing kind of started, is the idea you would place a bet on yourself to beat your opponent. I mean, if you go back to, Sullivan or even further, Mendoza, those guys were placing bets on themselves, and their supporters would place bets on them to beat their opponent. And so it seems strange to me that independent contractors, I can understand you can't place bets on other people because it opens up, or bets against yourself because it opens up the idea that there could be fight fixing. But to place a bet on yourself, it seems a little strange for independent contractors. I should know too, something interesting that came to my mind is we see some of these changes, and we have this waiver from class action lawsuit now inserted into the contract. Is I don't think it's not beyond a possibility that the UFC. Okay, we know that the reason they inserted all these changes, the 5-year provision, the sunset, the change to image rights, they got rid of the exclusive negotiating period for a while, but kept the matching period. All those were done in response to the antitrust lawsuit. Basically they admitted in that hearing in fall, but they have a waiver now, so they put it in to delineate, to basically put a barrier between the two antitrust lawsuits so that damages going forward would be mitigated, right? So because the original lawsuit went from 2010 to 2017, and then they had to file a new lawsuit in 2000 that covered 2017 on. So before 2017, all those damages are there because the contracts haven't changed. But from 2017 on, they have a new contract. So that should mitigate the damages. Now, what this waiver does is it keeps those fighters out of the antitrust lawsuit, right? They can't take part of a class action. They can do it themselves,
but that's really costly. Who's going to go in, hire the experts? The experts are costing them a fortune. They're probably paying millions on the economic experts. So who's going to do the regression analysis in an antitrust lawsuit on their own and risk losing the case and be out $100,000, whatever, in a lawsuit? So no one's going to do it on their own. So, but the waiver prevents them from joining a class action lawsuit. Well, what's to stop the UFC from clawing back some of these changes they made, right? We saw Ngannou just leave the UFC with the sunset provision. We see Paulo Costa is going to do it. GSP's sunset came up. I imagine that John Jones got a better deal because the threat that he was going to sit out and be out of his contract next year. With that in mind, what's to prevent the UFC, if they make fighters sign this, to say we are also, because we have this leverage, we are taking out, we're taking back the sunset clause and getting rid of it, or some of the other clauses, or putting in longer. I don't think matching period they probably won't do above 12 months, but put in the exclusive negotiating period, the matching clause, put in the bad, I guess the really bad declination provision they have back in, where there's no 18-month limit to it. Put that back in, and it's like those were in the antitrust lawsuit. The allegation is it's those provisions that help give monopoly power, but that doesn't mean anything because now they have a waiver. You cannot bring that to court, even if it's true.
All right. So to go back and circle to what you initially started out with, how is this legal for those that might just be joining in and listening right now? Maybe they didn't get the beginning of the show. How is this legal that they're making all these changes, or that they could potentially make changes like this?
Well, because I guess one is the Supreme Court rule that you can put in waivers for class action lawsuits. We have people don't pay attention. Our Supreme Court is loaded now with Federalist judges that are very pro-labor, like the Lochner Court in the 1920s and 30s, one of the worst courts in American history, and we might very well have another one like that. The other thing is, until this is challenged in court, everything's legal, right? But they put up barrier after barrier for challenging it. And so fighters are kind of stuck right now accepting these terms. I should note, too, we'll talk about other promotions. A lot of the stuff that you see in UFC contracts are in other promoters' contracts and are bad. But one thing you don't see in any of the other promoters' contracts is the waiver, the arbitration and the waiver from class action. I've not seen any fighting MMA promotion have that inserted in their contracts. That's specifically a UFC thing.
It definitely gives you a lot to think about. The amount of changes just we just did this, a month and a half ago, where we spoke about the contracts, to now. The wagering, the code of conduct being inserted in there, man, they didn't waste any time. And I'm wondering if the declination and the sunset provisions, if that was changed in response to Ngannou. Well, can you share when you got the contracts? Was it before or after Ngannou? I'm just curious.
I got them after Ngannou, but I can't say which ones were written up. Yeah, but also I don't know if they could have been written up. Who knows how long the negotiating period was. But I do think it's possible that the changes. I have a theory, and I can't prove this theory, but one of my theories is when Ngannou became closer to the end of his contract, right? Mm-hmm. That as it became obvious that he was going to leave because of the sunset, and GSP got out of his because of the sunset. You hear guys like Paulo Costa.
And Nate Diaz as well, right?
No, Nate Diaz had an older contract. He just had to wait forever, over 6 years to get out of it.
His was not the sunset provision that got him out, right?
No, Nate had no sunset.
Okay,
none. He just had to fight it was only a 5-fight contract, and it took over 6 years to get through. So that was his problem. But everybody else is using this new provision, and I think it's very conceivable that the UFC saw that more fighters were going to take advantage of this and decided that we have to make these contracts a little more restrictive than we had before, than we've done. And if we do that, we've opened ourselves up to more allegations from the antitrust lawsuit. So now that the Supreme Court has ruled these waivers are legal, let's insert this waiver for class action and put in this arbitration clause. And that way, if we want to claw back some of the stuff to make it harder to leave, so fighters cannot follow the route at Ngannou. In many ways, it's Ngannou's following the path of Randy Couture. Remember, he talked about how the contract, he found loopholes in the contract, and at the end result was they made it worse for all the other fighters. And so that we might be in another situation where the select few that took advantage of this is found this loophole because the UFC put it in there for the lawsuit, but now that they're finding a way to get around it to make it hard again. So that's a very strong possibility. The other thing is, they have a law firm on standby for them at all times, right? And they might just be going over, and every time they find something new that they can pick at to strengthen the contract, that we'll find a new provision inserted every 3 or 4 months, maybe.
One more question real quick. You said that the Supreme Court made these waivers legal back in 2018. Why did it take the UFC 4 years to get to the point where they're putting waivers in their own contracts? Was it just necessity dictated it, or?
Well, I can only theorize. I can only guess, I guess. But I mean, one is that they'd already made changes to the contracts in 2017 before the Supreme Court ruled on that case, right? So they'd already done it. And I can only guess because of the timing that they decided to only go ahead with these arbitration clauses because the first batch of fighters were taking advantage of those changes.
Okay.
And so they decided, like, you know what, I'm wondering if they didn't expect so many fighters to try to take advantage of that 5-year clause.
Okay. Anything you want to say in closing before we wrap up this episode? Because I do know you got your hands on some other contracts. Yeah,
we've been talking about this and we keep kicking the can down the road, but we promise eventually get to PFL and Bellator contracts. We'll go over those. And then there's a bunch, there's always stuff popping up we can talk about. It's an endless cavalcade of sleaze and combat sports to go over. So
were there any changes to the bout agreements, or have you had a chance to look at the bout agreements on these newer contracts?
Well, no, the bout agreements seem to be basically the same. So I haven't noticed that, but I'll go back and maybe I'll check. But the bout agreements generally don't change as much because they don't cover the intricacies that the promotional agreements do.
And boy, are they intricate. I'm just stunned, especially with Section 25's changes. Wow.
Well, yeah, and in hindsight, especially with Fedor Emelianenko's retirement, his conversation about how much he disliked those contracts back in 2007, it kind of full circle here. We're back to where he was.
Draconian contracts are coming back.
Oh, yeah. What's old is new again.
All right. So that's going to wrap up this episode. For those of you out there wondering, we're going to keep running this show. We're going to keep running all the Bloody Elbow shows. If you would like to sponsor this show, please email me, crooklyn949@gmail.com. John, do you have anything coming up that we should let the folks know about?
Well, probably not. No, I mean, I might be on If the Shoe Fits, the other podcast I do where we don't talk about MMA stuff. I might have some written articles about this. Because of the Bloody Elbow's current situation in Vox Media, it's up in the air what's going on with my deal. But maybe I'll put this on as text so people can read it. But other than that, no, I'm really lazy, so no.
Got it. All right. So until next time, you know the routine. Please stay safe.
Not in the face! Thank you.